Well, it doesn't come as a surprise. There are many people who have raised concerns about the manner in which the public protector approached this report. It is people are not sure whether she was obsessed with herself or obsessed with the president. The issue of being obsessed with herself was more about rushing to finish something so that it will have a lasting legacy that relates to her. Or secondly, whether she was obsessed with the president that she wanted to do so much damage that he could not come out of, even when she knew that the process was incomplete. So the president could make two arguments: that the report should not have been released until such time that all sides have been heard. So that would be one of the concerns that the president would raise. And the issue of whether she had abused her position and whether it was an obsession can be something that the court might want to look at. Because when you know, the act is very clear that when people are implicated, they have the right to ask for documents and also to question witnesses. That is in the law, that it's in the act of the public protector. So that party, she was under so much pressure. But instead of thinking of the interest of justice, she was more concerned about the legacy. So that is one question. The second question is that you have a collation of allegations. The question that might be raised is that is it fair to put allegations, even if they are not findings but observations? Because those observations are unfortunate in the sense that they did not dress other people in glory. That they may be observations, but they are also damning observations. And it might be, and it can be argued, that to do so was prejudicial to those people whose names appear there. Then thirdly, you also have an issue that has to do with the remedial action. The Constitution is very clear when it comes to who is empowered to institute a commission or judicial commission of inquiry. The way she has approached it, it almost violates or offends that principle that it is not a mistake that the Constitution had expressed itself in that fashion. So what she is doing is to second guess the Constitution. So she put herself above the Constitution. So that might also be raised. And the president has already alluded to that. So the idea of a review was always a given those concerns.
Also, the state of capture report in its inconclusive state would obviously leave a very huge cloud of doubt, not only on President Jacob Zuma, but on South Africans as well. What kind of effect would this have on the democracy of the country if things were to be left as they are, so to speak?
No, I don't think our democracy is in peril. Democracy is not a perfect science. It is an experiment. And now and then we are going to stumble. And this is why we have checks and balances, because we understand that people are fallible. So when people falter, it cannot be attributed to saying democracy is failing, because democracy had always anticipated such things. Even the court process and the judicial process itself is not perfect. So one must understand that we are involved in a very interesting experimentation called democracy. And sometimes it works for some people, sometimes it doesn't work for some people. There are winners and losers in a democracy.
Right, Professor SIPHO, thank you so much for your reaction and analysis there. Professor SIPHO over the phone line there. Joining us on the phone line now is Marius du Toit, is a legal expert. Marius, thank you for joining us once again this afternoon. President Zuma taking the state capture report on a review. What legal ground does he have? What arguments can we expect from his defense team?
Well, he obviously believes, and that's what I think, because obviously we haven't seen the papers which have been filed, but I would assume that he believes that the public protector has overstepped the mark in instructing him specifically, institute a commission of inquiry. I believe he says that is solely his authority, and that's the authority of the executive. And by doing so, the public protector has, of course, overstepped the mark. But the interesting thing will be the fact that we know that the Constitutional Court ruled that the public protector's reports are binding, and they are binding on government. But the question is to what extent, and I think that's what's going to be explored here. It's one thing to say, well, the public protector, her reports are binding, but the question is to what extent can she interfere with the executive function of the president? So he's absolutely within his right to bring a review application. He has to do so within a reasonable time. And the question will be whether the High Court will in fact adhere to it, or whether they agree with him and set it aside.
Now, Marius, the report also recommended that Chief Justice Mogoeng, instead of President Zuma, should appoint a suitable judge to lead the judicial inquiry into allegations of state capture. Doesn't that breach our constitution?
Well, that's exactly what I think the President will argue, is the fact that this is a function of the executive, that's his specific function, and that is what the Constitution has specifically authorized him to do. And by doing so, she's inter alia interfered with his executive functioning. So it's going to be really interesting to see whether the SEA, well, not the SEA, the High Court will, of course, agree with him. Being, of course, that if he leaves it, he is bound to do it. So the only thing he can do is, of course, to review it. So I think it's maybe the worst kept secret that he was going to bring a review application. But you have to say it was expected.
Now, should the judicial review fail, I'm not trying to jump the gun here, just what then happens? Does it mean that the President has to comply with the recommendations of this report?
Well, let's assume that the High Court disagrees with him and believe that his grounds for review are flawed. Then what will happen is the report will stand as it is, unless he appeals that decision to the SEA. So this matter can go all the way back to the Constitutional Court 2 years down the line, and in the process will be delayed, and no commission will be instituted until such time as legal process has been exhausted.
What effect does this have on the other respondents that are found in the state capture report? Should President Jacob Zuma go ahead with this review and perhaps actually win it?
Well, it will depend, of course, on what grounds he's reviewing it, because we don't know. I mean, if he's reviewing it on all grounds, let's say every single finding she has made, then, of course, the argument will be, well, then there should actually be parties to the application. But I don't think that's what we'll have here. I think he will focus solely on the fact that that he believes that her report breaches his executive functioning, and as a result, and of course the Constitution, and I think as a result thereof, the rest of the findings will stand. But should it be found that the report, let's say, be set aside, then it means, of course, the findings are set aside. But it will depend, once again, on what relief he's asking. He could ask and say, well, that portion of the report be declared invalid. Or he can say, listen, the report as a whole should be thrown out, and that it should be resubmitted to the public protector to reinvestigate. So there might be a number of grounds upon which you will go. He might even say that his right to have a right of reply was not properly adhered to. He didn't get enough time to fully respond to it. He didn't have time to question the witnesses. So all of that will definitely come into play in his review application.
So obviously the President has to do this within 6 months, but how do you see this playing out in terms of the timeline of when we can expect everything to become clear with regards to, what argument he's using and the outcome of the whole process?
Well, typically what happens is that when you bring a review application, you must file an affidavit coupled with the grounds upon which you want the matter reviewed. Then the opposing party will have an opportunity to respond to it. They will file what is called answering affidavits within specific time limits. And once they file the answering affidavit, once again, the President will have an opportunity to respond to the answers that was given by the then public protector. And then the matter will only be enrolled in the High Court for a date. And only when it's enrolled in the High Court will the High Court then call upon the parties to file heads of argument. And then the matter will be placed before a judge, and the judge or three judges, whoever, will then consider the merits of this matter at that time. So we can easily be in court maybe at the end of next year, maybe the year thereafter. It might take long, unless the Judge President believes that this is such a matter of great importance that he allocates an earlier date. But even if he allocates the soonest possible date, you still have time limits that have to be complied with by the parties. before the court can even consider hearing it. And that will at least take a couple of months.
Right, just very quickly before I let you go, Marius, does the President move to put the state capture report on review then jeopardize the merits of the findings of this report?
Sorry, just say that again. I broke up.
Does President Jacob Zuma's move to take the report on review then jeopardize the findings of the whole report?
Well, I think definitely it will keep the report in limbo. I mean, whatever she found in respect of in specifically pertaining to the president and any of the parties relevant to the president in the state of capture report will definitely be suspended pending the outcome of this ruling. Because any remedial action, remember what she did is she said, listen, I can't really make findings against the president, but there are certain things that bother me, and I believe that this should be fully investigated by a commission of inquiry, and that the judge president should, the Chief Justice should appoint such a judge to preside over the matter. So the fact that that has transpired, of course, will definitely mean that he will focus on that. But it's not to say that each and every other finding will now be affected as well, unless in his review application he attacks it, in which event it might mean that the whole report might be thrown out.
All right. Marius, thank you so much for your time here on NN7. Marius du Toit, he is a legal expert, just shedding some light on the legal aspect with regards to President Jacob Zuma taking the state capture report on review and what it subsequently means to the whole report and what the implications thereafter for himself. Just a recap there of our breaking news coming in. President Jacob Zuma to take the state capture report on review, and he is expected to do this within 6 months. Reactions coming from political analysts there, saying that it comes as to no surprise that the president had to do this, as he had a lot of concerns with regarding how the whole state capture report was. We have another political analyst on the phone line. I have to stop there. Professor HANYANE, thank you for joining us. News coming in there. President Jacob Zuma taking the state capture report on review. Any surprises?
Not at all with this about 10 decision. Although let us not forget that mid-December was the deadline for the president to ensure that the commission is up and running. However, we cannot just not be surprised and leave it at that. I think for him to have taken so many days to come up to this decision may very well bring forth the feeling and the element that once again there's a bit of delaying tactics on him to ensure that we close this year without necessarily having gone the more creative, rigorous process of ensuring that we're coming to the closure of the whole process. So in essence, it doesn't come as a surprise, but at the same time, it's worrying to note that the decision comes at a time when he's only left with plus minus 2 weeks to respond to the report itself, in suggesting that a commission should be established by then.
Right. And in the report, very concerning there that it had recommended that Chief Justice Mogoeng, instead of the President himself, appoint a judicial inquiry should it get to that. How do you see this panning out?
Well, that process will have to wait for a while and see where the review takes us. Quite rightly, the report states that Mogoeng must submit the name of the so-called credible judge, who will then head that commission with a fully fledged staff and ensure that the commission's work remains impartial. With the review process, we'll never know. It might take 6 months. It might take a year. It's anybody's guess now. So in a sense, it's playing out to his favor before the end of his term, first as the president of the ANC in 2017, and secondly working towards the end of his presidency in 2019.
Now, just going back to the whole state capture report, Professor HANYANE, allegations that perhaps Thuli Madonsela was making a political statement in releasing this report so prematurely.
I don't buy that debate. I've said this in studio with some of my fellow commentators who are subscribed to your station. I think this is the high time than ever before where we need to be rational about the whole process and ensure that by our side, constitutional experts are there to advise us. We may have a take in terms of due political process to be followed and to be observed. But let us not remember, there are so many experts involved in this process. You have legal, we have ourselves, we have economic analysts who must look at the issues in ESCOM in terms of the dealings made. So at the end of the day, so many heads must be put together and digest and analyze the report and basically preempt what is likely to happen and which steps must be taken by parties implicated.
Well, I suppose it then perhaps puts a dark cloud over the whole state capture report, doesn't it, and the merits of its findings?
I wouldn't suggest so. It was initially the right of the president and those who are implicated. We've seen this unfolding in the courts of law, later withdrawn and basically dismissed by the court with costs. So yes, it is the president's right to take the issue for review. There's no problem with that. The only issue that might come out from here onward is the unforeseen delays in the process, which will take more time than anticipated, especially aggravating those who would like to see the president see the light of day in terms of justice itself.
The other respondents to the state capture report, Professor Barry, do you see them taking the same route?
It is most likely, indeed. It is most likely. Remember, in the initial process of taking the matter to court, it was the president who led the process, and then, of course, followed by Minister Van Rooyen, yes, and Minister Zwane as well. So it is likely that they too, and together with those who are implicated, I might put into the hat here the name of Mr. Molefe, who would want to exonerate himself prior to the commission being established. And I remember vividly when I suggested this process to be a just, reasonable process to take, rather than allowing excitement and undue process to basically shadow the whole process. Let us be rational. Let us be reasonable about the whole saga. There are due process to be followed, and indeed one of them is the review by the courts.
Right, we'll see how this pans out. Professor Barry HANYANE, thank you so much for your time here on NN7, and your analysis is certainly appreciated. Reactions there coming through with regards to President Jacob Zuma releasing a statement through his legal advisors that he will be taking the state capture report on review, and this had to happen within the 6 months from the time that it was released. Well, President Zuma had also announced that remedial action in the Public Protector State Capture report will be taken on review, and the report was compiled by the former Public Protector Advocate Thuli Madonsela. It was released earlier this month after a court order. The presidency says the reasons for Zuma's decision to challenge it will be made clear in his application for review, which is currently being drafted. The report found that President Zuma should institute a judicial review into the allegations of state capture to be chaired by a judge chosen by the Chief Justice. Now joining us on the phone line now is constitutional expert Mr. ZEHIR Omar. Mr. Omar, thank you for joining us here on ANN7. What legal recourse should we see the president taking? Obviously now we know that he is taking the state capture report on review. What arguments do you think he will put through his legal team?
Look, the Constitution confers the exclusive power on the state president to set up a judicial commission of inquiry. The process involving the setting up of the Judicial Commission of Inquiry, that is also exclusively the function of the state president. Thuli Madonsela was clearly wrong in imposing upon the Chief Justice and making an order setting up a Judicial Commission of Inquiry, which the Public Protector does not have the power in law to do. In addition, yesterday's judgment handed down by Mlombo J, the President of the North Gauteng High Court, Pretoria, confirms the view that the failure of Thuli Madonsela to accede the polite request by President Zuma to have time to study documents and to properly reply and to cross-examine witnesses who made adverse allegations against him. These were all very irregular. So the question is now, does the law require President Zuma to take the report of Thuli Madonsela on review? In the Nkandla judgment, the Constitutional Court found that the recommendations of the Public Protector are binding. That would mean that the recommendations of the Public Protector, if it is indeed that of the Public Protector, must be taken to review. But the question then is the recommendations of Thuli Madonsela that is riddled with so many illegal statements, procedural irregularities, is it the recommendation of the Public Protector? In my respectful view, it is not. But the responsible thing to do is what our learned president is doing. He's doing it responsibly, and he's surrendering once again to due process of the law, which is always done. And President Zuma, in my view, can ignore Thuli Madonsela's report because it is not the report of the Public Protector, but it's Thuli Madonsela's personal report that is riddled with malice. But in the light of the proper submission to the rule of law, and as a responsible president, President Zuma has resolved to take the recommendations of Thuli Madonsela on review to the High Court.
So is it no longer mandatory for the president to institute the judicial probe until the report is reviewed, or can it create some kind of complications in the view that the Constitutional Court judgment making it implement of the remedial action of the Public Protector's report mandatory?
No, you see, the Constitutional Court is the highest court in the land. In my respectful view, the Constitutional Court was wrong. But we accept that the Constitutional Court judgment is correct because it made law. So the Constitutional Court found that the recommendation of the Public Protector is binding unless set aside on review. So, in compliance with the judgment handed down by the Chief Justice in Nkandla matter, President Zuma is now taking the recommendation on review. If it does not take it on review, it can be said that it is binding and it has to be implemented. But the Constitutional Court expressly found that the recommendation of the Public Protector is binding unless set aside on review to the High Court.
Right. So, in your view, definitely Madonsela crossed the line in suggesting this remedial measure that interferes with the President's constitutional power.
The President is doing that which is perfectly in accordance with the law. I can go so far as to warrant and guarantee this in my capacity as a lawyer who appears in the High Court, the Magistrate Court, the Constitutional Court, and the Supreme Court of Appeal. President Zuma is acting in strict accordance with the judgment handed down by the Chief Justice in the Nkandla matter. President Zuma is acting strictly in accordance with the law as contained in our Constitution, and in my respectful view, President Zuma is displaying the attitude of a responsible president who has completely surrendered to the rule of law.
Do you believe that Madonsela rushed through the report to somehow finalize it before her term ended? And was it important for her to do this? Could it not have been passed to the new Public Protector to have enough time to give the respondents, enough time as well to go through the report and give their arguments and respond?
You see, Thuli Madonsela, and I say this with respect, was very arrogant in publicly saying that President Zuma was informed of the allegations as early as March 2016. Now, to be informed of allegations and to be told to come and testify under oath is two hugely different concepts. President Zuma was told early in October, barely 2 to 3 weeks before the hearing, that he is required to testify. So President Zuma was absolutely correct in saying, give me a chance to study the document, give me a chance to cross-examine the people who made adverse allegations against me, and then I will continue. In that respect, Thuli Madonsela was totally, completely wrong. She acted unlawfully and unconstitutionally. And then the simple question to ask people in the DA and Helen Suzman Foundation and all the detectives of President Zuma, show me one provision in the law that entitles the public protector to force the president to set up a judicial commission of inquiry. Point out one section of the law that entitles the public protector to make an order binding upon the Chief Justice of South Africa. There is no such law. And hence, that recommendation of Thuli Madonsela, her investigation, is completely, totally unconstitutional and unlawful.
Right, Mr. ZEHIR, the constitutional expert, thank you so much for your time here on NN7. We certainly appreciate